I will stop the recording for now until I see that there are more people on.
Welcome, everyone, from wherever in the world you're joining us from. My name is Suzanne Rattray, and I'm the Vice Chairperson of the Board of Directors of the Lagos Chamber of Commerce International Arbitration Center, LACIAC for short. It's my great privilege and pleasure to welcome you all to the 5th edition of the LACIAC Live Debates, an initiative of our Thought Leadership Committee. We launched the first edition of the live debates in July 2020. And we've maintained this debate as a continuous series, having had 4 previous successful editions. Now, the LACIAC live debates are focused on developing and emerging trends and issues within the international arbitration community. And they provide a platform for arbitrators and arbitration practitioners to discuss these emerging issues. So we are grateful to those of you who have been with us from the very first edition for all your support. And if it's your first time being with us, we're very glad to have you here and hope that it won't be the last time that you're joining us for the LACIAC live debates. Over 150 people from different regions of Africa and Europe have registered their interest to attend this event. So it's our expectation that it'll be a lively and thought-provoking session. So let me stop here and hand over to our moderator, Madeleine Kimei. But before I hand over to Madeleine, I'll do a brief introduction of her. Madeleine is the founder of iResolve, a fully-fledged arbitration practice based in Dar es Salaam, Tanzania. Madeleine is in her 2nd term as the president of the Tanzania Institute of Arbitrators. She's a member of the court of LACIAC, Court of Arbitration, and a member of the ICC, International Court of Arbitration, serving in its ICC Africa Commission as an ambassador, the ICC Commission on Arbitration and ADR as a member, Singapore International Arbitration Center, SIAC Africa Users Council. Madeleine is a facilitator of online dispute resolution program under the International Law Institute in Washington. Madeleine was an awardee of the top 50 most promising young arbitration practitioners in 2020, winning a mentorship program with Stephenson Harwood in the UK. She serves on panels of arbitrators around the world, in the European Commission as a chairperson of arbitrations, Arbitration Foundation of South Africa, Hong Kong International Arbitration Center, the Tanzania International Arbitration Center, Shanghai International Arbitration Center, and China-Africa Joint Arbitration Commission, to mention just a few. So Madeleine, it's our pleasure to have you here as a moderator for this exciting debate. And I hand over to you to introduce our participants and to get the ball rolling. Thank you.
Thank you so much, Susan. Thank you, Engineer Susan Rattray, for that wonderful and generous introduction to the live debates, the 5th edition brought to you by LACIAC. Now, she has not mentioned that she was also the former chairperson of the Chartered Institute of Arbitrators Zambia branch and is also listed in numerous panels globally on arbitral institutions panels globally. Without any further ado, good evening to you all. Good evening and good morning to some, depending on where you are. We are happy to have you here. I feel very tremendously honored to be the moderator for today's 5th edition of the LACIAC live debates. The theme is set around artificial intelligence, a better neutral in arbitration and ADR. The motion before us for this debate is the effectiveness of artificial intelligence in resolving disputes is undermined by prosperity for data bias. AI, as we all have come to know, it helps in reviewing enormous amounts of data, which is involved in arbitrations and then of course, by segregating those relevant data and information for purposes of any particular case. And it is beneficial, as we have come to learn, in terms of reducing costs and time in the dispute resolution process. Now, that is not what I would wish to embark on at this point in time. I want to move on straight to introduce to you all our debaters. We have two iconic persons, women in the international arbitration community. I will start off by introducing Professor Catherine Rogers, who will be proposing the motion today. Rogers is a professor of law at Bocconi University in Milan, Italy. Catherine specializes in ethics and professional regulation and international arbitration. She is the founder and CEO of Arbitrator Intelligence, a legal tech startup. This is an online platform that connects parties and counsels who have information about arbitrators with users who need it. It promotes transparency, accountability, and diversity in arbitrator selection by increasing the access to critical information about arbitrators. Among other appointments, Professor Rogers is a reporter for the American Law Institute's restatement of the United States Law of International Commercial and Investor State Arbitration, and was a co-chair of the ICCA Queen Mary Task Force on third-party funding in international arbitration, together with William W. Park. Let me turn to Sophie Nappet, who will be opposing the motion before us. Nappet is an arbitrator in independent practice based in London. She is dual qualified as an avocat of Bar of Quebec, Canada, and a solicitor of the Supreme Court of England and Wales. Before becoming a full-time arbitrator, she pursued a career as an advocate and was head of international arbitration at a global law firm. She is commended as most highly regarded and a leading light in her field by Who's Who Legal. Sophie is highly sought after in complex energy, investment, and natural resources disputes. She is pioneering practitioner at the intersection of arbitration and legal tech. In 2019, she completed the University of Oxford's SAVE Business School program on blockchain strategy. In 2021, she co-founded ArbTech, a worldwide online community forum fostering cross-disciplinary dialogue on technology, dispute resolution, and the future of justice. In its first year of experience, ArbTech was shortlisted at the 2022 GAR Awards. Sophie is trained and has practiced in both civil law and common law jurisdictions. She holds degrees in both common law and civil law from McGill University and master's degree in law from King's College London. Sophie is an award-winning lecturer and the first female recipient of the Global Arbitration Review Award for Best Speech in 2016. She created the first prize in international arbitration open to young scholars and practitioners worldwide, administered under the auspices of McGill University. Sophie also acts as a mediator, and all of her profile can be accessed on 3Verulam Building 3VB website. Now, the format of the debate today will take about 40 minutes. We will first have the proposition for about 15 minutes, and then the opposition, and we'll have rebuttals for each side. We'll have a Q&A for 10 minutes, and the debaters will have a final address, and then we will have a closing remark delivered by our keynote. A few housekeeping issues. For the debaters, well, when a minute is left, there will be a bell that rings. Please wrap up when you hear the bell. To all the participants, you are encouraged to submit your questions for the debaters in the Q&A box below. As a disclaimer, please note that whatever positions or opinions taken by each of the debaters, it does not mean or necessarily represent their personal views, but are mere opinions or positions adapted for purposes of this debate exercise. Before we proceed, I invite all participants to take the pre-polling vote at this moment that would appear before your screens. Okay, we have poll 1, which states, do you agree that artificial intelligence in ADR is undermined by the prosperity for data bias? We have not received any response. Out of the 22 who have participated, we have not received any response at this moment in time. This makes it even more exciting. And so therefore, I would move on straight to our first debater who would be proposing. And I welcome you, Professor Rogers, for your presentation. You have 15 minutes.
Thank you so much, Madeline. And I am going to go ahead and actually start a PowerPoint presentation, which I understand is a little unusual for this format, but it's a topic I thought might be benefited by some visual images. So with that, I thought it would be good to start with a basic definition of what artificial intelligence is, just so we know what we're all talking about. I'm not going to go into too many of the details of the at a definitional level, except to identify sort of different levels. So generally speaking, at a most generic level, we have something we refer to as artificial intelligence. It's in many ways very generic. It just refers to the study of design of intelligent agents, making essentially machines able to, quote unquote, think. Machine learning is a more specific type of artificial intelligence, which involves having a machine able to learn and adapt without following explicit instructions. In other words, in a sense, it teaches itself. The machine does some of the teaching. Deep learning is a sort of a stronger version, a subset again of machine learning, which involves algorithms inspired function that is actually mapped roughly on how the human brain works with artificial neural networks as opposed to simple algorithms. What I wanted to focus on in this talk is artificial intelligence, any one of the 3 levels we were just talking about, as the final judge or decision maker in the underlying dispute. So I'm not going to address, and I'm not as skeptical about artificial intelligence as a tool for legal research, which we actually all already use, whether we realize it or not. Artificial intelligence as a tool for judicial administration. In many parts of the world, it is already being used in that capacity, proving to save time and money, make judges' jobs easier. Not as a data management tool, which is, again, something that AI is very adept at and has already been used quite a bit. And not AI as a tool to guide settlement. There's some interesting AI-driven platforms out there that actually help parties reach an agreed upon settlement amount. Instead, I want to speak about and focus on the idea of AI as substituting for the actual decision maker, for the adjudicator, and how that would affect us, particularly in light of known biases or the propensity for bias in the data and actually in the algorithms, in the teaching of its own development of algorithms. So first, I wanted to start with the observation that we're all sort of already deeply swimming in artificial intelligence everywhere. One comment on technology is, if you are not paying for it on the internet, you are the product, meaning that all sorts of websites that you visit record your data, oftentimes notwithstanding various data protection rules. This is an image of facial technology, facial recognition technology in China, which has its own, I would say, justice writ large, not dispute resolution justice, but social justice. And they're using facial recognition software to assign points in terms of whether you're sort of a good citizen or a bad citizen. I think most places in the world that will not be happening as expressly as in China, but certainly it raises some issues. Other types of collection of data that can be used in AI is most obviously your telephone. There are 14 different sensors on your telephone, all of which collect information about who you are, what you do, what your preferences are, what you look like, what are your daily activities, where you are. And these are all data points that could be used in AI-driven analysis, either in a case or obviously in other things outside of dispute resolution. So before now when we understand what artificial intelligence is, how steeped we are in it, now let me talk briefly about how bias creeps in to artificial intelligence. So one of the most basic ideas of artificial intelligence is that it is teaching a machine. The way the machine is taught is through what's often referred to as training data. And training data, the data that is used to train the machine to think, can be biased in several different ways. And actually, I'm going to focus on 3, but there are some permutations below each of them. So on the one hand, you can start with data that is itself inherently biased. Data that, for example, preferences one group over another. And I will give examples in a few minutes that'll make some of these categories more clear. So if the data is biased, we all have heard the term garbage in, garbage out. So if you have biased data and you feed it into a machine that's going to process it, of course, the outputs are going to be biased as well. Sometimes the data overall might not be biased, but you might have to take a sampling of the data that you're going to use to train the machines, and you would have and the data that you pick as part of your sample may intentionally or unintentionally have bias built into it. And again, I'll show you some examples. Third, and I think this is particularly relevant for dispute resolution, you cannot teach a machine through machine learning to do some of the most complex types of analysis. And so what we end up doing is breaking down what the ultimate decision we want and having the decision maker, the machine, essentially decide based on proxies. I'll give you a few examples of those in a minute. In addition to bias that's essentially a byproduct of the training data or of the data that's originally fed into the algorithm or into the machine, machine learning can itself generate bias. And one of the problems with this kind of bias is it becomes self-reinforcing. And again, I'll give you an example of that in just a moment. So one of the points to make about these theories about how artificial intelligence can be biased is that we already see these biases. They are around. One of the most famous examples is Amazon, that had developed what seemed like a huge solution, a time and money saver, to be able to identify the best applicants for jobs. It was an AI-based, an artificial intelligence-based recruiting tool. And it could process CVs, review them, and select them at a rate that obviously humans could not. And it was seen as this great innovation. At the time it was introduced, everyone wanted it. But it turned out it ended up starting out biased against women. And it also ended up becoming more and more biased against women. So 2 reasons: it was biased against women, and it wasn't because it was set up to be that way. But as it was learning, it was identifying what qualities and words in CVs were essentially predictive of good employees or employees that they wanted to hire. It turned out that there was a correlation between gendered terms, such as on the women's debate team, and employees they didn't want to hire. So what the machine ended up teaching itself to do was essentially strain out or discount the value of CVs that had the words that had feminine connotations. The other, again, very unexpected bias that crept in was there were words like effectuated, executed, and it turns out that those verbs tend to be unexpected, I guess, before it was implemented, used by men much more frequently on their CVs. So what looked like a very neutral tool for processing who was going to get hired or not ended up building into that process a strongly gendered preference for men, and a preference that was unseen for a long time. Well, okay, that's a business activity, and we might not care so much. I mean, I think just disparity in hiring is obviously a big problem, but we might not care about it as much, or we might not care about it as much, for example, if Netflix recommends a movie that we would never actually watch based on a misperception of our sort of viewing habits. But when we come to dispute resolution or justice, I think we're talking about an entirely different set of stakes. And in fact, even in this context, we have seen, particularly in the criminal justice system and in the United States, some truly disturbing instances of bias. So there was an algorithm adopted in Broward County, Florida, that actually ended up oftentimes mislabeling African-American defendants as high risk of recidivism. At twice the rate, it mislabeled defendants. So the error rate, presumably it got many of them right, but when it did get them wrong, it was really a very, very much biased against African-American criminal defendants. And there were many other instances in the criminal justice context, particularly another algorithm-based, AI-based judicial assistance tool was the corrector offender management profiling for alternative sanctions. And it was used by judges to make determinations about how long should a jail sentence be, what should a bail amount be. And it ended up, similarly to the Broward County example, overestimating Black recidivism compared to white recidivism. Another one is more in the direct law enforcement context, PredPol. The idea was that artificial intelligence could help identify where crimes are most likely to happen and send the police there. If you are feeling a little creeped out that this is very similar to that movie Minority Report, in fact, it is. The reason why this didn't happen, and it sounds like a really great time-saving tool for police officers, the problem was that it would identify crimes that had happened historically, and it kept sending the police to those places more often than to places where they didn't happen. Those places happened to be heavily populated with minorities. And because they kept sending the police there, the rate of crimes reported and prosecuted were increasing. And so in what started out as a mild form of bias essentially got activated and accentuated by the algorithm itself, sort of feeding itself. In addition, we had some ID software that was intended to identify faces, and it had a false positive matching women's faces at a rate of 1 in 10,000, meaning you would, false positive. If you ended up being identified, you had a 1 in 10,000 chance as a woman to be misidentified, but only 1 in 1,000 chance of a Black woman being misidentified. Suggesting, once again, if these are tools that are going to be used to decide the outcome of people's fates and justice, very profoundly disturbing. Now, it's not always the case that AI misfunctions. Sometimes it can function perfectly well as it's intended to, or with a very high degree of reliability. There is actually some artificial intelligence that's been developed that can guess very accurately, much more accurately than human beings, whether a person is gay or straight. And its accuracy when it's looked at 5 photographs was 91% of the time it guessed accurately whether men were gay, and 83% with women. Now you might think, well, what's wrong? I mean, it actually, if it's guessing right and it's accurate, that's a sort of good thing. Doesn't that help? But then when you start thinking, for example, about ways this might be abused by governments, and then again used, amplifying that abuse if it's imported into the dispute resolution system. There are some places in the world where being gay is illegal or criminal, including actually in the United States. There's some fear that it might become criminalized in some states. What if police departments or judges start using artificial intelligence to, in a sense, predict the likelihood that a particular person is gay and use that as evidence against them in the case. So I think even when AI provides some accuracy, it still raises some troubling questions. It is in many ways like phrenology, but worse. So phrenology was an ancient pseudoscientific technique that was based on the theory that the shape of our skulls actually indicated various personality qualities, including your propensity towards criminality. Now, it was demonstrated relatively soon after its emergence to be, a pseudoscience. And of course, the shape of our skulls doesn't determine many things about us, including whether we have a criminal propensity. But it was taken very seriously for a long time. And I think the risk of it being taken seriously in the dispute resolution setting is once again much higher. And we think, okay, well, dispute resolution is how different is that than, let's say, the policing instances that we looked at, or just mere sentencing issues. I started researching to see, because I thought there must be places that have tried this. And in fact, there was a big article in Wired magazine, and then it was cited in several others, that in 2018, Estonia implemented what they called an artificial intelligence judge, a robot judge, they called it. And this is the Wired, the cover from that article. It was a really big deal. Amazing things. It was supposed to be for smaller disputes. You think, okay, well, that might make sense. But it actually did not. It was exaggerated as a report. I actually think it seems to have been some movement in that direction, but you find on the Ministry of Justice's website from Estonia that the article about the robot judge was misleading. They are not developing a robot judge for small claims procedures or for any court procedures. And what was interesting to me is how many times the robot judge had been cited, that article, and how few, and actually there were no other citations that I found to the Ministry of Justice's attempt to change that perception, nor was there any explanation of why they decided against what many people commenting on the initial misleading article seemed to think was a really great idea. Small stakes disputes could be resolved efficiently and therefore to everyone's benefit, because it's, otherwise justice can be expensive and time consuming. So, why didn't it fail? Well, unfortunately, there is no explanation on the site, or again, commenting on the Ministry of Justice, just lots of anticipation to see what was going to happen here. But I have a couple theories about why it failed. And that is because one of the things that is essential for a dispute resolution system is for it to have legitimacy and for it to have the trust of a populace, whether it's an arbitration system where they're opting into arbitration, or it is a public justice system and a court system. If it does not have the imprinter of legitimacy, and it does not have the trust of the people who are going to be using it and who will be subject to its decisions, it can't succeed. And in fact, there were some interesting experiments. I think they had a number of methodological limitations, but they tested basically a number in experiments where they gave scenarios to two different groups, and to see whether they would be willing to submit disputes to an algorithm-based decision maker versus a human judge. And here you can see what was interesting to me is low complexity, which presumably might also overlap to some extent with low value. It didn't seem to affect at all people's, and maybe even had a higher variation with people's willingness to submit their disputes. So, whether it was highly technical disputes, high emotional complexity, one of the major assessments of why AI couldn't replace judges is that in certain contexts, human emotions are very important. You might think family law, but also I think criminal law. There might be some aspects where human emotion is really important. And that's one place where AI is particularly poor. In addition, I think one of the things that was suggested in in assessing whether judges should be left in charge or AI is even if you have accuracy. And again, going back to the predictions of whether an individual is gay or straight, there was actually research done by a US university that wanted to see if they could have AI identify based on faces criminality. And that was actually, there was some indication that they could have significant success. This would be a sort of retrospective effect to see, if you showed them a picture, you're not predicting their future criminality, but you're using their face to say, can we essentially determine based on their face who ends up in jail and who was not. With the idea, however, that if you could, based on someone's face, identify their propensity for criminality, that might be a tool in decision-making on the merits of whether they should be punished or not, or at least that would be one imaginable implication. That study was, oh, sorry, am I over?
Yes, 5 seconds.
Okay. I didn't hear the bell, I'm sorry.
It's okay.
Okay, I'll wrap up here then, thanks.
Thank you, Professor, for that wonderful proposition on the effectiveness of artificial intelligence in resolving disputes is undermined by prosperity for data bias. Now, we turn to Sophie Knappert, who would be opposing this motion. And without any more time taken, Sophie, I hand over the torch to you.
Thank you very much. I will not have slides, so I'm afraid you're going to have to look at me for the next few minutes. My argument against the proposition in one sentence is that when one speaks of bias that gets in the way of the resolution of disputes, algorithmic bias is more verifiable and more predictable than human bias. And here I squarely place myself in the area of commercial disputes, which are the disputes that often come to arbitration, or low value, high volume disputes. I agree that most of the very spectacular examples of mishandling of data by AI due to bias have to do with the criminal justice system, and that in that field, it is probably very true that bias has a consequence that is very undesirable, and its consequences are a lot more far-reaching than they might be in the disputes that come to arbitration typically. My proposition in opposing what is the topic that we are discussing today is that allowing AI to do what it does better than humans, and Catherine has given us a lot of examples, and I will give you a few more, allowing it to do that has the potential to lead to a better resolution of the disputes that come to arbitration. Arbitral decision-making, let us not forget this, as we practice it, and as we see it today, is replete with human bias that is unchecked and often uncheckable. None of us is shielded from this, and it is a scientifically verified fact that the human mind operates under bias that is completely subconscious. Importantly, unlike human decisions made by machines, by artificial intelligence, can in principle and increasingly are in practice, as the examples put forward by Catherine have shown, they can be opened up, they can be examined, they can be interrogated. How do algorithms learn? Machine learning algorithms learn by considering only the variables that improve their predicted accuracy based on the training data that they use. These variables, that training data, are verifiable components. By contrast, even allowing for the infamous black box of machine learning algorithms, when one wants to look into and review the actual factors, not the factors that human arbitrators say that they use, but what goes on up here, in the process of coming to a decision, it's a much more difficult exercise, if not an impossible one. So by allowing AI to partner up with human decision makers, we could forge a promising path to thinning out the layers of human bias. And here I'm going to open a quick parenthesis to say that I am not putting forward the argument that either an algorithmic or a human decision-making system would ever be free of bias. I think we have to allow in both cases for the fact that given that you have human coders, human bias is going to enter into the machine to a point. My proposition is that algorithmic bias is more predictable and more verifiable than the human bias. Dispute resolution by humans has shown itself historically to be plagued by a number of bias-related factors that have become crippling over time. And I will argue that they are threatening the survival of arbitration as a dispute resolution mechanism in the digital economy. I will mention here two of these factors that are of the human mind that are crippling the decision-making in arbitration. The first factor is the chronic limitation of human ability to review and process large, complex, repetitive volumes of data. And that's a truism. At the same time as arbitration is urged by its users to become a faster and cheaper process, international arbitration in modern times involves ever larger volumes of email correspondence and Excel spreadsheets that are becoming beyond the grasp of the human mind in these shorter deadlines. And so this chronic limitation, as we know, creates and fosters delay, cost, and backlogs that inhibit access to justice. So that's the first factor that cripples the process as we know it now. The other factor is something that is brought to light by the authors Daniel Kahneman, who is the former author of Thinking Fast and Slow, I'm sure known to many of you, Cass Sunstein, the guru of nudge, and Olivier Sibony in their book of 2021 called Noise. What do they mean by noise? They mean what they call the unwanted variability of human judgment. A well-known example of which, again in the criminal justice context, is the parole board decisions that vary depending on whether or not the case is considered after lunch or before lunch. So how does AI step in to assist the human mind? So given these two factors, I'm coming back to them. The first factor, the brain's limitation with vast amounts of data, has shown to be spectacularly solved by AI. I think we all agree with that. There's a very positive example of this in Argentina, where an algorithm called Prometea has been applied since 2017 by the Public Prosecutor's Office of Buenos Aires to accelerate the resolution of minor or routine offenses and therefore free up time for the analysis of complex cases. Just to give you an idea and to have some stats on the table, they are quite striking. Prometea can predict the solution to a court case in less than 20 seconds with a 96% success rate. It can prioritize urgent cases out of a huge volume of files in 2 minutes, which would normally take a human being 96 days. And it can draft 1,000 judicial decisions, sentences, relating to housing rights, for example, in only 45 days. The traditional way by humans would take 174 days. So to come back to the proposition, there is no question that in the quest for better and faster justice, humans need help. So the second factor I was talking about, which is the noise that Kahneman et al. Are talking about, the variability or unpredictability of human judgment. So this goes to the other facet of the proposition. Human unpredictability stands in the way of just and fair decision-making. And this is not as readily solved by AI as the issue of data handling and processing, because it involves a consensus on how we define fairness and how we define a just outcome. And once that definition is accepted, how we translate it into code. So it is not noise is not a readily solvable problem. However, as the authors of the book suggest, although a predictive algorithm is in an uncertain world, is unlikely to be perfect, it can be far less imperfect than noisy and often biased human judgment. Notwithstanding machine learning and the algorithm's ability to learn on its own, its performance vastly outweighs that of the human mind in terms of validity, because good algorithms will overall predict better than humans, and in terms of reliability, because the algorithm is trained to decide like cases alike, so quite predictable. And importantly, the machine does not get hungry for lunch. So I am arguing emphatically that provided there is the right dialogue between the legal profession and the developers and coders of algorithms, the artificial arbitrator will and should be the future for a certain type of disputes for two reasons. My first reason is that as we raise the bar for automated decision-making, because it's quite interesting, and I'm going to put a little parenthesis here, it's quite interesting that given bias in AI and bias in humans, we are much less forgiving of bias in the machine than we are of our own human bias up here in the mind. Because the machine is a machine, we expect it to get it right every time, which of course is not the way it works, especially since this is a field that is developing constantly. We are not on top of it, technologically speaking, by any means. So as we raise the bar for automated decision-making, the opportunity arises to hold human decision-making to a higher standard as well, and rethink the standards we use to determine when human decisions are fair and when they are not. For example, we often accept outcomes that derive from a process that is considered fair, a procedural process such as due process, but due process is procedural fairness. It's not the same as outcome fairness. And another proxy that we often use is so-called compositional fairness, meaning that if a group making a decision contains a diversity of viewpoints, then what it decides is deemed fair. These have traditionally been the best tools we had, but as we begin to apply tests of fairness to AI systems, we can start to hold humans more accountable as well. And the second reason why I think I would propose that the artificial arbitrator has a future is that trust is at the core of arbitration and dispute resolution generally. In the age of e-commerce and the Web3 economy, the disputants in that space will place their trust in a dispute resolution system that matches their values. What are these values? Ease of access, immediacy of result that they find in the online interactions and transactions where they operate. The matrix of time is a powerful argument in favor of AI. Human judgment, in addition to being biased, is time-laden. The decanting of thought processes is valued and it is necessary. This is at odds with the concept of time as it is understood and as it exists in the digital economy, and discounting the assistance of algorithms in decision-making has the potential to make arbitration obsolete in this developing space. So can I please urge you to vote against the proposition and in favor of the future of arbitration? AI is not a search for perfection, but for the steady optimization of the decision-making process, thinning out the existing layers of human bias. Thank you.
Thank you, Ms. Knappett, for that argument against the motion before us. We have heard clearly both ends of the motion, and we have had examples put before us. But before we proceed to the Q&A session, we do have a rebuttal for each side to present against each other.
So I will try to keep mine short since I went over before. I think we do have various mechanisms for correcting human error, and it's called an appeal. And so one interesting question is, if you have an AI decision maker, what is, do you not have any appeals? Can you not have any appeals? Are parties willing to give up appeals? Now, in international arbitration, that appeal is not a major part. Substantive review is not a major issue, but also for the courts, how does an AI essentially express reasons that can be tested by a court for those bases for which reasons would be appropriate for the court to be reviewing. In addition, I think this is one of the key issues. It is possible, obviously, to identify bias. The examples I gave you, they identified the bias in the AI, but it isn't always. And in fact, there are a number of scholars who talk about the potential for artificial intelligence to hide, to speed up, and to deepen discrimination, all the while seeming neutral. So we have a sort of dichotomy in the sense that people mistrust machines, but as Sophie suggested, in fact, oftentimes they are more consistent than human decision makers. But that potential, that machine potential to seem infallible, I think suggests that it might be harder to challenge when they do make errors. In addition, I think there have been examples where even when they identify a bias, they cannot even figure out why. So there was a bunch of MRI tests that was determined that MRIs were systematically misdiagnosing African Americans, and they had a number of theories about where the AI might be going wrong. But even with that information, knowing it was biased on something as concrete as a physiological test, they couldn't identify the reason and correct it, despite a number of theories. So if that's the case if it's decision making in a case, and you as the losing party genuinely believe that there was a mistake by the AI, you wouldn't be able to challenge it. In arbitration, there's no appeal, but also on other grounds under the New York Convention would seem to be difficult to challenge. We talked about process. What kind of process, is that a 5.1b challenge? But I think the larger question is, if you can't identify it, it does seem much more disturbing if it is a machine than human error. And I believe personally that the concept of adjudication is an inherently a human process, and that we count on it being a human process with all our flaws. Artificial intelligence might be able to make us more efficient, might be able to help us identify and reduce our biases as humans, but ultimately adjudication means one human being evaluating the party's arguments and evidence and making a legal decision. Thank you.
Thank you, Professor Rogers. Ms. Nappet.
I will only say that the problem is not so much the bias within the AI. The problem is how the humans perceive technology. And at the moment, because we are unused in this partnership that I'm positing of the AI doing what it does best and the human doing what it does best in the arbitral process, because we are unused to that partnership, the human mind and the human brain, or the brain of the decision maker, tends to be completely subservient. If you give them a result that's been or an outcome that comes from an algorithm, the first reaction is to say, well, that must be right, because the machine, has got to be right in its numbers, and that's the wrong approach. But that's not a problem with AI; it's a problem with the human, and the human decision maker has to learn to question, to at least have the right alarm bells ringing. There is a very good example of where this can be tested, and it has been tested in the public procurement arena, where the abuse of public funds, signs of the abuse of public funds, has been unearthed by an algorithm that was trained to look for the data. One can readily see, and we're hoping to introduce this in the ICC task force on corruption in arbitration, but one can readily see something similar to be done in order to find out red flags that are indicative of corruption in arbitration. This is something obviously that we're looking to the future, but for this to happen, the human decision makers are going to have to look at AI as a tool, as opposed to as the ultimate decider of those issues that have been tasked to a human to decide. Thank you.
Thank you, Sophie, for that rebuttal just within the minute there. Now, having done the rebuttals, and I think we're very much in a tight positioning here. Professor has made a very good case on the proposition, and the arguments against that proposition are even much more aggressive. And so let me move on to the questions before we deliberate any further. I have one question here on the Q&A box. It comes from an anonymous attendee. It says, thank you very much for your presentation, Catherine. Can the bias that AI tends to show not be corrected to ensure better use of it for arbitral decision-making? Professor?
So thank you. It's a very good question. I think the answer is sometimes. There are some instances where, for example, the CVs for Amazon, it was not only identified that there was bias, but also the reasons for the bias. And to some extent, they could be corrected. Interestingly enough, Amazon discontinued use of the program altogether because it wasn't seen as reliable after that. And I think Sophie's point is human beings make all sorts of, biased assumptions. There's been tests about CVs being given where you change the people's name from the same CV given with a female or male name, and in fact humans are very biased as well. And I think there is a point to what Sophie argues, which is we expect more of the machine, so we're more disturbed when we see bias. But I think that there are also times where the machine actually creates the bias. So for example, the sending the police to a particular place. I mean, what the algorithm actually generated facts, right? The outcome was that the police were being sent to a place. So of course they were finding more crimes in that neighborhood, which happened to be a low income neighborhood with minorities. And so it was actually accurate later in saying, oh, that's a higher crime area. But it was because the crimes that were being caused because the algorithm kept sending the police there. So there can be ways that the algorithm itself aggravates the bias. And in some of those instances, I think it's very difficult to identify. And I think to some extent, Sophie and I don't disagree on everything is so much as, I think it really comes down to the question of the ultimate decision maker. And as I understood, Sophie was not saying she necessarily would assign all these cases to the ultimate decision to AI. I also think there are a number of things that AI just can't do. For example, if you have evolving social norms, if you have new cases that, new instances or applications where there is no historical background, maybe it can, in a sense, predict where it thinks, based on historical data, the direction of the decision should go. But I don't think we want machines making policy or evolving the law. That's one place where I certainly wouldn't trust machines. But I go back to the idea that for all their flaws, human beings should be the ones adjudicating, even if we could eradicate the bias in the AI.
Thank you, Professor Rogers. Sophie Nappitz, would you like to have a go at that as well?
Yes, of course. So thank you for the question. And the question is, can you sort of improve the bias situation? My answer to that is I do think that as we become more used to using, more familiar with using AI as a tool in decision making, we will, in the same way as you are questioning the values or the underpinnings of an expert witness calculating lost profits, for example. In that same way, you can certainly question what kind of data has been fed into the algorithm and how it makes the decision that it makes. And these questions don't always have an answer at the moment, but they will in future. And so I am not, as I said, I am not positing that we are looking with AI at a bias-free decision-making process at all, but hopefully the partnership will allow the human bias to lessen, and at the same time, the human will keep a check on the AI. its way of looking at certain patterns. That to me would be the optimum solution. I remain of the view that so that's a very obviously metaphysical question. What is justice? Do we want human justice? Does a human have to be involved all the time? And that's a question, of course, for society to ask itself. But I look at the online economy, the Web3 economy, the digital economy, and what I'm seeing is a speed of interaction and a matrix of time that with which we have as decision makers and as users and as stakeholders in the arbitral process, we have to grapple with, because there is a huge challenge. The process as it is right now, completely human-based and with minimal help from technology, is not viable in that space. And that in itself, I think, has to be the wake-up call.
Very interesting argument. There has been this awakening towards this field of needing there to be some sort of level of policy or regulation around it. What are your thoughts on this? Before we move on to the next question, and I encourage other participants to post their questions on the Q&A box.
Is the question to me? Sorry, Madeline.
Yes, yourself.
On whether we need more regulation of the there is obviously a need for regulation, because there is, at the moment, it is the Wild West out there, and governments and authorities are a little bit behind, because this is a field that moves at such speed. So that is, but as far as the arbitral process is concerned, I don't think we should wait for regulation at all. I think we should go forward and decide police our own system, which is the way that arbitration has always done. Make our own rules and look at our own process, because after all, we know that process. We know what works. We know where the tension points are. And once we do that, then we remain relevant in a field that does need our help, because where you have transactions and behind the avatars, you have humans. When you have transaction, when you have money exchanging hands, and it's no small amounts of money, you're going to have disputes. And so in order to remain relevant and to make sure that those disputes are fairly decided, we have to look at the challenges and meet them.
Thank you, Sophie. And Professor Rogers? On the same issue of whether there is need for a regulation or policy around this, a global approach?
Well, so I guess I would take a similar view to Sophie, with one distinction, which is I think that the international arbitration community regulates itself largely. And so to the extent you're talking about regulation, I don't think it would be useful for or helpful, generally speaking, for state regulation to come in and determine how AI might be used in arbitration. But I don't think that means no regulation. I think it means internal regulation. So arbitrators, arbitral institutions and bodies such as the IBA have stepped in to provide regulation of arbitrators, of parties, of third-party funders. And so I think this is another area where it might make sense to have some internal deliberation, which I would put under I would say prevailing scholarly definitions of regulation. So I agree with Sophie that you wouldn't want external national, legislative regulation, but I don't think that means no regulation. I think it means we have to police ourselves.
Thank you, Professor Rogers. There's some sort of consensus here between the debaters. There's a question here from Babatunde Fagbonlu. Apologies for the pronunciation. Now, he first of all thanks the debaters for the stimulating discussion, stepping into and out of the character that he has had. It will be great to know if there are particular disputes that the debaters consider that AI is better suited than humans, and if there are others where it is the other way around. So he's asking around what kind of disputes are particular to the artificial intelligence.
So do you want me to start, or Sophie, if you wanted to start, you're welcome to. So I think, first of all, AI is already used in many contexts, but not as the final adjudicator. I think that's where I draw the line. And it's been very useful. There are some settlement platforms that actually do help parties by essentially regulating how they submit their proposed settlements, getting them to agreement. I also think that so-called dispute resolution sort of depends how you define dispute resolution, but eBay has a very elaborate online essentially dispute resolution system. The main difference, and it's algorithm driven, and the disputes tend to be, because on you know, a platform like that, relatively routine, right? There's only a handful of, you know, the product didn't arrive, the product arrived broken, the product arrived late, product wasn't what I asked for, you know, 2 of them arrived, none of, you know, so I mean, there's a really limited spectrum of disputes. But even there, if you don't like the outcome, if you disagree with their algorithmic driven outcome, you can then go to adjudication. In other words, I think what categories of disputes, the smaller ones tend to be more amenable to algorithmic driven outcomes. But I also think that because someone's small dispute, you know, we're all, by virtue of being on this call, very privileged. If you ordered something on Amazon and it's small to me, it could be very big to you, or very emotionally important to you. So I'm all in favor of eBay's online algorithmic driven, and they call it an ADR, dispute resolution process, but I don't believe it should be or could be binding on the parties. In different jurisdictions in the world, they can be bound by it, because it can be called arbitration. At least in some places in the United States, it can be considered binding. But I think the difference is it can drive parties closer to settlement, but shouldn't be imposed on them as the final decision maker.
Thank you, Professor Rogers. Ms. Nappet?
Thank you. The Prometea algorithm in Buenos Aires, I think, is an excellent example of the types of disputes. They're repetitive, they are predictable, there is a huge data set. So for example, a taxi license that has not been renewed or that has been wrongly granted, that sort of thing. These types of disputes, I think, have been shown to be spectacularly well decided by AI. And frankly, insofar as AI can then be used as a tool for rapid access to justice, then I think it should be allowed to do so. As Catherine says, in this field of work, we are at one end of the spectrum of disputes that are very high stakes, very complex, multi-party, multi-jurisdictional. This is not for AI, obviously. But there is a whole rest of the spectrum of other types of disputes where people, without algorithms, just cannot have a recourse. And it's not going to get it right every time, just like a human doesn't get it right every time, but it can do a whole lot of good. So for those types of disputes that Prometea, for example, is addressing, for the disputes that eBay is addressing, pay the claimant, don't pay the claimant, there is no reason in my, and again, it's a matter of where does the user's trust go? It is a new thing. At the moment, justice by a machine may be off-putting for some people, but in certain parts of the world where the justice system, the commercial courts just do not work or completely out of reach, it's a very attractive proposition and should not be discounted.
Thank you, Ms. Nappet. And I think just to build on to that, there is a question here on the development and advent of cryptocurrency. Is there a case study, Kathleen Bomani asks, to look at or learn from this form or arbitration look like in this advent cryptocurrency future? Or is it still Wild West, she asks?
And Sophie might be better positioned to answer this, but when you have, I mean, the whole proposition of a smart contract, especially one that incorporates cryptocurrency, is to, in a sense, narrow dramatically, if not completely, the range of possible disputes, and to, in a sense, have some automatic enforcement that's effectively pre-agreed to. But again, on a very limited range of issues, and cryptocurrency and blockchain contracts certainly, go together. I'm not sure now that there's been this disruption with cryptocurrency's value, maybe people are a little less, and blockchain's been hacked, people might be a little less thrilled about it, but I think parties can opt into those kind of processes. I guess my question is, if that fails and then they therefore have a claim to bring to court, if the machine gets it wrong, how do you appeal that, number one? And how do you even, it seems very difficult to argue, what would you bring on appeal, I guess. And I'm not sure that that's completely obviated by cryptocurrency or smart contracts to the extent that there's a residual claim left over.
Ms. Dappert?
Kathleen, thank you for your question. And thank you for bringing me on to my pet topic. The advent of cryptocurrency and the blockchain is obviously a completely uncharted territory for dispute resolution. Yes, you do have case studies to look at the moment. There are applications on the Ethereum blockchain where that are called arbitration. Huge grain of salt, but they are peer-to-peer dispute resolution. So you have users of the blockchain that stake a certain amount to self-select as dispute resolvers of those disputes that take place on the blockchain, mostly about, at the moment, the curating lists of tokens and so on and so forth. So that's a form of dispute resolution that has emerged with the advent of cryptocurrency. Cryptocurrency is an ecosystem that is driven to a very high level by community and by trust and by emotion. As I'm sure you've seen with the huge volatility of the value of that asset online. So when I talk about arbitration having to look at this squarely in the eye, we can laugh at the lack of due process that this peer-to-peer dispute resolution system provides. But if the users of that ecosystem trust that process and find that its outcomes are, on the whole, fair enough, and by the way, these are humans making decisions on these particular blockchains at the moment, but I could very well see that when the data and the types of disputes grows in number, they will be replaced by algorithms. But if they trust that outcome and if they find it sufficiently fair and they get a decision within hours, they're going to go for it. Why would they go to 3 off-chain arbitrators appointed by word of mouth? We're going to take 6 months to a year to decide the dispute. It makes no sense. So that's what I mean when I say, and thank you for asking that question, yes, cryptocurrency, yes, blockchain is presenting us with an entirely new world of transactions where disputes are going to arise and where they have to be solved.
Thank you, Ms. Nappert, for that great elaborative answer to Kathleen's question. And indeed, cryptocurrency and blockchain is here, and surely in the near future, it will continue to grow as a marketplace. And so therefore, we do need to think around how to resolve the disputes that are underpinned within those platforms that offer these services. Now, prior to the closing remarks by the debaters, we do have a second poll. I would ask that poll to be aired now for voters and the participants to take their vote immediately when they see it appear on their screens. You have now probably seen the poll number 2 before you. Please do make your vote now. We'll give it about a minute and a half. Now then, we're still going down, 43 seconds in. We've got 15 out of the 25, out of the 26 that are participating. We'll still wait for the rest to make their decision. It's a very difficult decision. Strong case being made by Professor Rogers. She's argued on the effectiveness of artificial intelligence. Okay. The voting is still taking place. And I think I will end it now. Thank you very much. The poll has ended, and a very interesting results before me. The question again posed, do you agree that artificial intelligence in ADR is undermined by the prosperity to data bias? Yes, no, or not sure. We have 24% saying no. We've got another 24% saying that they're not sure. And we've got a 53% saying yes. Yes, they do agree that artificial intelligence in ADR is undermined by the prosperity for data bias. Now, that's a very interesting end to our debate. But just before we make a close to the debate, I invite both debaters now to make their final addresses, and they have 5 minutes each to do so.
I won't take a full 5 minutes. I will say very interesting results. I actually would call it probably a tie, because 48% went, where Sophie, they said no, but to the extent that she was able to get them unsure, it seems to me that that's a tip in her favor. These are really interesting, complex questions. I think the one thing that comes out from both Sophie and my presentation are that you fail to understand and learn about artificial intelligence and to engage with it meaningfully at your own peril. Artificial intelligence is with us everywhere. And if to the extent what you want to do is understand why you don't like it, so you can sort of check against it, even that requires learning it. But it is in the future. It is going to affect all aspects of our lives, as it already does in many, many, many aspects of our lives. My one holdout is with regard to the final decision in adjudication. I'm fine if parties use it to settle. I think it can be incredibly effective. I'd be fine also if I don't know exactly the details of the Argentinian system, if it sort of gave the parties an outcome, and then if they don't like it, they can sort of like a mediated outcome, they could sort of go to dispute resolution before a judge. But I do think if you're not already aware of what it is and learning about it, I guess you are for sure here at this program. And thank you very much actually to the, I would say, vision of the organizers on this. One thing I did see was there was actually some effort at developing AI for dispute resolution in Africa. I think it was called Africa 86, Court 86, but it sort of disappeared from online. There was one article mentioning it, but clearly artificial intelligence is big for Africa. My one caution, though, is to the extent that the biases exist, they tend to be with the newcomers. So a lot of the biases against women is because there's just a lot less data on women in high positions, a lot less data probably on international commerce with regard to developing countries in the South and in the East. And so I think actually audience here, to the extent that's where you're from, you would be on the losing end of the bias. But at the same time, I think our lives will all, also benefit tremendously in efficiency and in various ways from the use of AI. And hat tip also to Sophie for doing such a great job in arguing against it. And once again, I have to say thank you. I'm so impressed with this organization. It was really a pleasure to be able to participate.
Thank you, Professor Rogers. Ms. Nappet?
Thank you very much for indulging me to make some closing comments. I think I would like to take a bit of a more metaphysical look at this, because underneath these questions are pillars of our society and of democracy. Do we want humans to remain at the center of decision-making and justice, both at the commercial level and elsewhere? There is an extremely interesting article in the Oxford Handbook of the Ethics of AI by Professor Norman Spalding of Stanford. And he's asking a very simple question: is human judgment necessary? And do we want to have humans at the center of decision-making in a society when you have machines that sometimes can make it better, faster, more cheaply than humans? He argues, of course, in favor as a pillar of democracy, and he's obviously looking more specifically at the US Constitution, which is where he operates. But I think that is a question, a very live question for the future, as technology becomes very, very adept at doing things that we're not so good at, and how, again, we partner with, and where we draw the line as to, you know, technology not going further than a certain point. Because let's not forget, in an era where we are used to tech giants taking the field, as it was the case in the Internet 2.0, and now we're looking at blockchain and the metaverse, and Meta, formerly Facebook, moving very aggressively with huge resources in this field. Is if we are going to rely on technology to reach justice and decision-making in the courts and in arbitration, then these big players will probably come in with their resources and their knowledge and take the field. Is this something that is desirable? And these are very important questions that this debate has allowed us to probe a little bit. And so thank you very much indeed for putting that at the helm of your event. Madeline, thank you for a fantastic job at moderating.
Thank you, Ms. Nappet. Thank you very much, Professor Rogers. I was very privileged to have moderated this debate. You know, we have heard proposing wise that the data that is fed into and into that trained machine it's either it's garbage in, garbage out. We've heard of the fact that the quality of the data would affect the end decision making in terms of its level or in balance as to bias. Of course, we've also listened carefully to Nappet's opposition, and she quotes Noise by Daniel Kahneman. And I was reading Noise, and one quote that I would like to also point out is that he says that as long as algorithms are not nearly perfect, human judgment will not be replaced. That is why it must be improved. So the benefits of AI, we've heard from Professor Rogers and Nappet, and the opportunities that it brings and presents is of high significance, and that it is not a statement that is just put into question, but we are already seeing it develop before our eyes. And so the AI can, of course, build stronger systems or stronger criminal justice systems, but we're yet to see. These are questions we're leaving behind for us all to ponder on. The arguments made today, remember, are not the positions or opinions of the speakers or the debaters. They have argued this debate for purposes of the debate itself session, and so therefore please note this disclaimer once again. I therefore welcome Engineer Suzanne Rattray to deliver the closing remarks.
Thank you very much. And insightful debate on this really current issue, I mean, beyond the emergent, I mean, a current issue of artificial intelligence and its use in resolving disputes. And of course, the ever pervasive issue everywhere, human or artificial, in data bias in resolving disputes. So I really like to commend the debaters, Professor Catherine Rogers and Sophie Nappert, as well as our moderator, Madeleine Kimay, for the wonderful job that they have done today in sharing their thoughts with us and teasing out the various aspects which we need to really come to terms with. I also would like to thank really the chairman of the Thought Leadership Committee of LACIAC, Dr. Babatunde Ajibade, for his leadership of the Live Debates program. I should have introduced him at the beginning. Apologies for that, Dr. Ajibade, but I'd like to invite you now to make some closing remarks.
Thank you so much, Susan. Well, just to add my voice, first to thank everybody who's participated and to thank Professor Rogers and Sophie Nappert for such an engaging debate on what is a very, very important topic. I sent a message to Tunde Fagbonlu a few minutes ago saying that the one good thing about this, at least where arbitration is concerned, is that the basics of arbitration ensures that parties in arbitration have a choice. They can choose whether they want to use AI or they don't want to use AI. I think the real hot chestnut is when you don't have a choice, where AI is imposed on you, then it becomes really problematic. But I guess it's with us now. And events such as this, discussions such as this, hopefully will give people a bit more insight into the pros and cons and give them the opportunity to make up their own minds as to just how far we want to go. So thank you very much, everybody, and thank you for participating, and we look forward to seeing you in LLD 6.
If I can just add a little plug quickly before we all log off, I just want to invite our audience to take part in some of our other initiatives, such as the 4th edition of our Dispute Management in Africa Infrastructure Projects, DMAP training, which is a hybrid event taking place in Accra virtually, in Accra, Ghana, as well as virtually on Zoom, this coming Monday, 31st of October and Tuesday, 1st of November. It's, I believe that a link is being shared in the chat box for the attention of anyone who's interested in registering. It's a training workshop on managing risks, claims, and disputes in infrastructure and construction projects in Africa, focusing this time on oil and gas, power, and renewable energy and public infrastructure. So really, we urge you, anyone who's interested in those topics, to please look in the chat box for the link and join us. And thank you all to our participants and our debaters and moderator and everyone. Please keep following LACIAC on LinkedIn so that you're up to date with all our events and initiatives. And we look forward to seeing you all at the next LACIAC live debates. Thank you all and goodbye for now.